Assalamu alaikum. Welcome to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, the Free Legal Advice Show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can ring on the landline number which appears at the bottom of the screen. Alternatively, you can send a message on the mobile number which also appears at the bottom of the screen. Sending a message on the mobile number, that's a very popular way of getting in touch, so please do continue to send your questions in on that mobile number. A couple of minor points before we get going. It's a live show. There may be callers who have complex queries. It may be that I need to look at documents before I can advise properly. Now, if it's the case that your matter is complex or I need to look at documents before I can advise you properly, then I'll ask you to leave your number with the control room and I'll have a more thorough discussion with you off air. Please do continue to send your questions in. Let's look at some of the questions that have been coming in today. The first question that's come in is from Ansar, and her question relates to an extension application for her spouse. And let's have a look at her question. And she says that my husband came to the United Kingdom on a spouse visa. His visa expires on the 11th of October 2025, so we're about 10 months away. I just want to know about the visa process for my husband, as his visa will be due for renewal on the 11th of October 2025. Okay, now it looks like, as far as this question is concerned, that husband will be completing or would have completed his first 2.5 years in the UK by the time you get to 11th of October 2025. So it's the first extension of the spouse application that we are looking at. Now, in one sense, the extension application is similar to the initial spouse application in the sense that there is an English requirement that needs to be fulfilled, slightly higher level. The main similarity is the financial requirement. In the same way, when your husband came to the United Kingdom, you satisfied the financial requirement. You showed that you were earning £18,600. In the same way, when you apply for an extension around October 2025, there is a financial requirement which again needs to be fulfilled, and that is, it's still the same. You would need to be earning £18,600, or your husband would need to be earning £18,600, or your combined earnings should come up to £18,600. So the financial requirement applies. The amount you need to be earning is the same as what you would have shown when you applied for the initial visa application. The only difference now is that it's not just your income that's going to be looked at, or it's not just his income that will be looked at. It could be combined income. So that makes things much easier. It could be that you're working, you've got a good job, you're earning that amount of money. It could be your husband's working and he's earning that kind of money. Or you're working, both of you are working, combined, your income meets that requirement. Now, off the top of my head, on a weekly basis, if you're working around 32 hours a week, with the national minimum wage being what it is, you should be able to comfortably get to that mark. So it could even be 16 hours each, part-time work for both of you for a period of 6 months, and that would reach the financial requirement as well. So the process: you have to submit an application. There is an English language requirement, slightly higher than what your husband did last time. It's an A2 application, the A2 level English this time. Financial requirement I've talked about. The only other requirement that you need to satisfy really is that you have to demonstrate that both of you are still living together. And the way that's demonstrated is by showing proof of bills, bank statements, letters coming for both of you at the same address over the last 2.5 years. So if you're applying around September, October 25, then you'd be showing your residence, you're living together for the period 2023, 2024 and 2025. So in a nutshell, that's what you will be doing. The form that you will be completing is form FLRM. Really, there are 3 things that you will be doing. English language requirement at A2, the financial requirement, which we've talked about, £18,600 per annum, unless an exemption applies, and proof that you're living together by showing your letters, bills, bank statements coming to the same address over the last 2.5 years. Now, let's have a look at when you can apply. Let's have a look at what type of fees you're going to have to pay. In terms of when you can apply, you can actually apply as soon as your husband has been living in the UK with this visa for 2.5 years. So you don't necessarily have to wait until the 11th of October 2025. As soon as he has completed 2.5 years in the UK, you are able to apply for the extension of his visa. That's the first thing. Secondly, in terms of fees, I can give you the current fees. Currently, the fees come up to, with the application fee and the NHS fee combined, both fees have to be paid, it comes up to around £3,885. So combined, it's £3,885. That's the application fee and the NHS fee. If you aren't able to pay those fees, it is possible to apply for a fee waiver. If you apply for a fee waiver, the downside normally is that it only applies if you're going on to the 10-year route to settlement. So currently your husband would be on the 5-year route to settlement. So he would qualify for indefinite leave to remain after 5 years in the UK. If you can't afford the fees and you apply for a fee waiver, then you would have to go on to the 10-year route to settlement. So he doesn't qualify after 5 years in the UK. He only qualifies after 10 years in the UK, after having done a number of 2.5-year extensions. So in a nutshell, that's where we are. The application is, it's an online application. The online document is referred to as an FLRM document, further leave to remain based on marriage. I've explained what the key requirements are in terms of what the Home Office will be looking at. We've looked at when you can apply, and we've looked at typical fees as well for making this type of application. Now, because you're going to be making an application towards the second half of the year, it's possible there might be a slight increase in terms of application fee, in terms of NHS fee. I can't see there being a significant increase, to be quite honest. We've had quite a significant increase over the last 12 months in the application fee and in the NHS fee. So I can't see any major increases coming in. So although currently we're looking at fees of around £3,885, it might go up slightly by a couple of £100. So you might just want to budget for around £4,000 or thereabouts when it comes to making the application in September or October of 2025. So that's basically how you go about making the extension application after your husband has completed 2.5 years in the UK. Okay, let's look at the next question that's come in. Now, it's an interesting question that's come in. And this is to do with, and I will read the question out. It's to do with the English language requirement when you apply for a spouse visa. And the question is this, and this is what the person posing the question, Yusuf, is posing. He says, I have a question regarding the A1 life skills test. My wife has A levels in accounting, business studies and economics. Just wanted to check, in those circumstances, is an A1 test still required? Now, understand where you're coming from. The background obviously is this, and by the way you've put the question, you obviously appreciate that there is an English language requirement when your wife initially applies to come to the United Kingdom. So you appreciate that she needs to pass a test. Your point is, look, she's got a fairly high level of qualification already. Is that accepted? It's an A level. The problem is this, that the Home Office will only accept certain qualifications for the purposes of fulfilling the English language requirement for a spouse application. And GCSEs and A levels are not currently on that list. They are on the list for other types of applications where you need to fulfill the English language requirement. But in terms of the spouse application, which is what we're talking about, which is what Yusuf is asking us about, GCSEs, A levels are not on the acceptable list. So in those circumstances, wife would need to pass an English test, and by the looks of it, if she's managed to do A levels in those subjects, her command of English is probably quite good. In which case, although the requirement is that she simply needs to do an A1 test in English, it might be better if she does the higher test. She does the B1 test, she does an IELTS test, and getting the higher results will be useful when it comes to extending the visa, when it comes to applying for permanent stay in the United Kingdom. At those different stages, a higher level of English test has to be, a SAT has to be passed. And if we do that at this stage, then that certificate, that pass mark can be used again for the extension and for the indefinite as well. So, in answer to your question, unfortunately, it doesn't work. It does work for certain types of immigration applications, but not for the type of application that you're talking about. She's going to have to do a test. And what I would suggest is that she just does a higher test, an IELTS test. Speaking, listening, probably just get the reading, writing done. It's not necessary, but it'll probably come in handy here if she ever has to prove her English. And if she's managed to do A levels in those subjects, I have no doubt that her command of English is actually very good. So thank you very much indeed for that question, Yusuf. Let's look at the next question that's come in. And that's a question from Brother Abdul. And his question, I was just looking at it very quickly, relates to an application based on 20 years residence. And he says, Salams, I previously applied for permanent stay. My case went to an appeal. The judge accepted that I had been living in the UK from 2005, not earlier than that. Can I apply for indefinite now? Because the judge has already accepted that I have resided in the UK since 2005. Now, this is not uncommon. where somebody makes an application based on 20 years long residence, their evidence isn't sufficient, they go to a hearing, and the judge then concludes that, you know what, I accept that you have been living in the United Kingdom. I don't accept that you've lived in the United Kingdom from the date you say you have. My view is that you've lived in the United Kingdom from a later date. Now, if the judge has made that specific finding, so if the judge has specifically said that, yes, you have lived in the United Kingdom from this date, I accept your evidence that you've lived in the UK from this date, then that is very helpful for you. When you apply for 20 years long residence, when you submit the 20 years long residence application, again, you can include the decision of the tribunal where the judge said that he is of the view that you have lived in the UK since 2005. So my view is work out precisely what the judge is saying in terms of from when in 2005 you have lived in the UK. So if I give you an example, if the judge has said that you've lived in the UK from February 2005, then you are able to apply for a visa based on 20 years residence in February 2025, so 20 years after the date on which the judge accepts that you've been living in the UK. On the other hand, if the judge just said, I believe you came to the UK around November 2005, then it's too early to make the application. Wait till November 2025. That would be 20 years of residence in the UK from the date the judge has already said he believes that you've been in the UK from. So go off the date that the judge has already given you and base your application on that. So by all means, yes, definitely, Brother Abdul, submit your long residence application again. I hope this time you will stand a better chance, backed up by the decision of the tribunal where there is sort of a positive finding in your favor already. Thank you very much indeed for that question. The next question that's come in is from Amr. And what Amr says is as follows. Assalamu alaikum, brother. My wife has passed her B1 test, but the life in the UK test is still in progress. For her indefinite, which we need to do now, can I rely on the B1 test and then she can pass the life in the UK test for nationality? So Amar is asking about whether when you apply for, Amar is asking about indefinite leave to remain, and what he's asking is for the purposes of the indefinite application, is the B1 test sufficient? If wife cannot pass the life in the UK test, can she just simply postpone that and pass that at the nationality stage? Now, I understand where you're coming from, and I've actually seen a number of people make the same point. They believe that only the B1 test, which is the speaking and listening test, only that's required when you apply for indefinite leave, and then when you move to the next stage, the nationality application, that's when the life in the UK test is required. So they think there's two stages: indefinite, just need the B1 test, and then the nationality application when you need the life in the UK test. It doesn't actually work like that, Amar, unfortunately. When you apply, or when your wife applies for indefinite leave to remain, she will need both the B1 test in English and the life in the UK test, apologies, and the Life in the UK test as well. So she needs to pass both. Now, the problem is this: if she can only pass one test, what do you do? Well, in that case, she would have to just apply for an extension of her visa. So she'd have to apply for another 2.5-year extension. Potentially, if you fulfill all the requirements to stay on the 5-year route, so your income's fine, etc., then she would just simply get the extension on the 5-year route. Then as soon as she passes the Life in the UK test, she would be eligible to apply for permanent stay in the UK. So she wouldn't have to wait to complete 2.5 years of another 2.5 years in the UK. Now, it depends really, in my view, how long your wife's got. My view is, look, if your wife still has a couple of months before she needs to apply for her indefinite, then hold off. Try and get her some training, try and get her to go to a tutor who can help pass the test, and then try and sit a number of tests before the current visa expires. Now, if you find, despite your best efforts, wife isn't really making any progress at all, it's not really happening, she's not going to pass the test. If you find she's not going to pass the test, then fine, okay, let's then change tack, change the process. Apply at that stage for the extension, but I wouldn't give up at this stage. Sometimes I find that where people have a deadline, so they know they have to get something done, and the deadline is, look, you've got 2 months to do it. Sometimes that helps people to focus, helps people to put the effort in when they've got that looming deadline. So it might be better for wife to continue, studying, get intuition, and try and pass both tests. But in answer to your question, Amar, wife does need to pass both tests at this indefinite stage, and it's a common misconception that it's only B1 at the indefinite stage and it's Life in the UK at the nationality stage. That's not the case. You pass both at this stage, and there is no further language requirement, Life in the UK test requirement at the nationality stage. So that's where we are. But thank you very much indeed for that question. Let's look at the next question that's come in. And that's a question from Kiran who's come in. And Kiran has an interesting question. Kiran's question is about a spouse application. And what she says is, Assalamu alaikum, I just have a small question. In terms of wage slips for my husband's spouse application, can my father do the wage slips for me in his own business? So can my father do the wage slips in his own business? The answer is yes, actually, but it comes with a but. Yes, but there are some conditions which need to be satisfied. The best way to look at it is this. In a normal application where you're sponsoring your husband, your wife to come to the United Kingdom, generally speaking, you just need to show 6 months of wage slips. The problem is this, that where you've been working or you will start work for a business which is owned by a close family member, it could be a dad, brother, sister, uncle, aunt, cousin, etc. The problem is, in that situation, if it's a limited company that they operate, then it's not just the last 6 months of wage slips that you show in order to support your husband's application. You'll have to submit 12 months of wage slips, and it's not the last 12 months, it's 12 months which falls within the financial year of the company which they operate. So the company's financial year might be June to June, so it could be June 23 to June 24. So if that, or June 24 to June 25, you have to show your income during that period, the financial year of the company. So my general advice is, look, it's doable, but there are certain conditions, additional onerous conditions, which need to be fulfilled if you're working for a limited company owned by your family. Now, the other thing is this, an application where you're working for family is also likely to be scrutinized more closely anyway. So sometimes it's easier because people don't want to wait for this amount of time. Sometimes it's easier simply to show your employment with somebody completely independent as opposed to with a family member. So Kiran, I hope that answers your question. It is possible to rely on family business, but there are, for limited company employers, there are additional requirements which need to be fulfilled. Now let's look at the next question that's come in, and that's from Brother Amir. And Brother Amir asks a very interesting question, and something which comes up quite a lot in practice. Amir says as follows: Assalamu alaikum. My mother is currently in the UK on a visit visa. Her health is not that good. She suffers from arthritis, diabetes, high blood pressure. Would it be possible for her to extend her visa in the UK, or for her to settle in the UK? Now, the question that Amir is posing is in practice something that comes up quite regularly. Now, the problem is this, that it's not an easy application, it's not straightforward. Generally speaking, the position is this, that if you come to the UK as a visitor, then you're expected to go back. There is no category under which you can apply to stay in the UK on a permanent basis just because you're ill, just because you need care. Your application would be made outside the immigration rules on human rights grounds. And the problem is this: however strong your case is, the general approach adopted by the Home Office is to refuse these applications. So applications by elderly people who have come to the United Kingdom on a visit visa, who need the care and support of their family members in the UK, generally they are refused by the Home Office. Sometimes they give a right of appeal, sometimes they don't. But if you get a right of appeal, then this is something that you can argue before the court. I can give you some tips in terms of when an application is likely to be successful. What you're trying to demonstrate is that the person's intention when they came to the United Kingdom was to come simply as a visitor. So there was no deception in them applying to come to the United Kingdom. Their intention was to come as a visitor. It may well be that their condition has deteriorated whilst they've been in the UK. So that's the first thing I try and demonstrate, that the intention when they came to the United Kingdom was that of a visitor, i.e. they will visit, the family members in the UK and go back. For whatever reason, normally, and this is generally the case anyway, the health has gone downhill and the need for care has increased. So the intention as a visitor was genuine. What you then try and demonstrate is show that the person's illness is such that it needs personal care. You have to show that there is the need for personal care really for you to be able to engage human rights laws and for you to be able to get a right of appeal. So how do you demonstrate that there is a need for personal care? Well, there are certainly two things you can do. One is provide a statement in terms of the care that the person needs. So it could be that you will explain that, you know, the person, my mother, father, whoever it is, let's take mother as an example, wakes up in the morning, we have to help her go to the washroom, we have to help her with showering, we have to help her put clothes on, we have to help feed her. Generally, she's not mobile. Whenever she needs to go to the washroom, we need to take her. At night, we need to help her get into bed, etc. So, a statement explaining that is helpful. What is also helpful is a letter from a doctor or an expert in this area explaining the level of care that this person requires. So that's quite helpful as well. Now, if you explaining a statement, the level of care that's required, if you get a medical report explaining the illness and that there is a need for personal care to be provided, then although in my experience the Home Office will still refuse the application, you may still have a chance before the tribunal if you get a right of appeal. One of the things that the Home Office will try and argue is that there may well be family members back home where the visitor has come from. So when they applied for a visit visa, they might have said, you know what, I have a son here, I have a daughter here. If that's the case, the Home Office is likely to say, okay, I understand you need personal care here, but why can't you just go back? If you go back, you've got your daughter, you've got your son to look after you. Why do you need to be cared for by UK children? Why can't your children who are abroad look after you? Sometimes you have to address that by explaining why they can't look after you anymore. It could be that they've left the UK. It could be that they themselves are ill. Or they are simply unwilling to provide that level of care and support that you need. But these are, Brother Amir, notoriously difficult applications, and in my experience you have to take it in stages. You get the application in as strong as possible. Don't expect that application to be successful. Hope that if it's refused, at least you will get a right of appeal. You then exercise your right of appeal. You go to court, and hopefully armed with all the evidence we've talked about, and with the judge hearing your live evidence, with your lawyer arguing your case, hopefully you will be able to convince the judge that this is an appropriate case where a visa should be granted and that it breaches human rights law, particularly the right to family life, if your mother in this case was required to leave the United Kingdom. So that's basically where we are. Let's look at the next question that's come in. Now, the next question that's come in is from Sister Anisa, and she says, I have a question about applying for my mum's visit visa from India. I have recently got my spouse visa. At the moment, I have no job, no earnings, no bank balance. What are the chances for me to apply for my mum's visa? Can I do it, or do I have to find another sponsor for her? She has been in the UK once before, it was a long time ago. She's also been to Canada in 2019. Please advise on this. Now, Sister Nisa, thank you very much indeed for that question. Your starting point is this. You're saying, should you sponsor your mother for her visit to the United Kingdom? You've said quite clearly in your question, you're not working, you don't have a bank balance. I think you've said you've recently come to the United Kingdom from Canada on a spouse visa. I wouldn't advise you in those circumstances to being a sponsor for your mother. You would be better using another close family member, if possible, to be the sponsor. Somebody who is ideally in employment and somebody who has around £2,500–3,000 in savings. The reason for that is, what we don't want is for your mum's application to be a strong application but get refused because they don't believe you are able to maintain and accommodate your mother in the United Kingdom. Now, if your mother is financially really well off, then fine, yes, you don't need wage slips, you don't need to have any money in your bank account. You can simply say, look, you know what, I live here, there's sufficient space for my mom to come and stay with me, so I am going to be providing accommodation, but I'm not going to be providing any type of financial support. That in reality doesn't really apply in most cases. In most cases, it is better to show a sponsor, a financial sponsor in the United Kingdom. So that's why what I would advise is that because of your circumstances, financially you're not strong at the moment, rely on a family member. So what you could do is, let's say you have a cousin here in the United Kingdom, and he could say, I wish to sponsor my aunt to come to the United Kingdom. I am employed, these are my 3 months wage slips, this is what I earn, this is what I have in my bank account. And you could also provide a supporting letter, a statement to the effect that, yes, I do want my mum to come to visit me in the United Kingdom. She will be living with me, although my cousin is the main financial sponsor. So we've dealt with both things in that situation. We've dealt with the fact that there is somebody who can financially support her. She doesn't need money herself. We've got that covered. And by you as the daughter also saying that, look, she's going to be coming and living with me as well, we've also shown a strong reason as to why your mother wants to come to the United Kingdom. It's to visit her daughter. The daughter wants to see mum, mum wants to see daughter. That's a strong reason as well. It's stronger than aunt coming to see a cousin, which is can be very strong indeed, but it's always better to have a much more closer relationship, especially when children are sponsoring their parents. It's always, it stands a better chance, in my view, to get a visitor visa approved. Now, you've said mum's been to the UK before, we don't know when. You've also said mum's been to Canada before in 2019. Very helpful. That's something that they do obviously ask about. They are certainly plus points. We can certainly mention that in the application, these 2 plus points should include evidence of her passport with her entry and exit stamps for both countries to show that, you know what, he is somebody who complies with immigration rules. She enters, when she says she's going to enter the country, she left the country within the time that she is required to leave the country. So you show, in terms of those 2 visits, you show that this is somebody who is compliant. That certainly increases the chances of getting a visit visa again to the United Kingdom. Now, having said all that, I would advise again that definitely, despite having a strong sponsor, despite her previous visits to the UK, she should still demonstrate what her circumstances are like in India in terms of close family, husband, dad might be there, in terms of other children who are there, in terms of her own income and her own financial circumstances. Demonstrate all that as well, along with the previous visits to the UK, along with the strong reason for wanting to come to the United Kingdom and having a strong financial sponsor in the UK who is sponsoring the visit. A complete application is something that you should be aiming for. Don't assume that just because she was granted a visa on the last occasion, she will then automatically be granted a visa again. That's not necessarily the case. The Home Office always says we consider applications on their own merits each time you submit the application. So do bear that in mind. But Anisa, thank you very much indeed for that question. Another question from Adil in terms of a visitor visa, and he says, well, there's a number of things he said. One of the things he says is, I will be applying for my mother-in-law's visit visa. She has been refused before. This time I will be demonstrating that my father-in-law works, and based on that, what are her chances of successfully applying for a visit visa? The problem is obviously we don't have the complete picture here. The starting point always is this: if there's been a previous refusal, you have to, or if there's been a number of previous refusals, you have to study the refusal. You have to look at the key points that they have referred to, that they have come up with to refuse the application. Generally what you find in visitor refusals is there's normally 3 or 4 points that they make. A lot of the time it's around finances, ties to one's home country, lack of evidence of close family members in their home country, etc. Normally it's not a problem with the sponsor in the UK, but the starting point is, look, if your mother-in-law's visit visa has been refused before, look at the points on which the application was refused. Work out what your explanation is in respect of each point. I know you've said in relation to your question that you're going to be demonstrating father-in-law's income. That's all well and good. I think that's important to demonstrate the couple, mother-in-law and father-in-law's financial circumstances. But even on that, what kind of evidence do you have of the income? Do Do you have wage slips? Does the money go into their bank account? Or are they self-employed? What kind of evidence of self-employment do they have? Do they get rental income? Do they get pension income? So it's not as straightforward as saying, well, we'll just show father-in-law's income. Really go into as much, drill down, really try and prove whatever you're trying to prove. So if you're saying my father-in-law has his own income, and you know what, that wasn't included before, now I'm going to show my father-in-law's income, fine. What's the evidence of that? Does your evidence, he may have that income, that's not the point. Does your evidence show that he has that income? If he's employed, do you have wage slips? Do you have an employment letter? Can you show money going into the bank account over the period of time that the person's been employed? So, Adil, to wrap up on this, look at the previous refusals. Why has the application been refused? Address each point in your new application. And if it was the case that it's a refusal based on finances, it's not enough to say in the application form that, look, they've got this amount of money coming in. You have to back up what you're saying in black and white with strong evidence. If you can do that, then it may well be that your mother-in-law stands a chance with her visitor application. But best of luck with that. Now the next question that's come in is from Shabazz. And what Shabazz says is as follows. He says, Assalamu alaikum. I am an oversteer in the United Kingdom. I am in talks with my family about getting married in the United Kingdom. If I was to get married, will I get a visa from within the United Kingdom? Or do I have to go back? Common question, Shabazz. A lot of people are here in the UK currently who, for whatever reason, have become overstays in the UK. And what you find is those who are in their 20s, 30s, etc., will over time, through their families, etc., find a partner to get married to, somebody to settle down with. The question that then arises is, based on the marriage, Islamic civil registry, whatever it is, based on the marriage, would the person who's here and who's overstayed their visa, would they be able to get the right to stay here in the United Kingdom, or do they have to go back? Now, the answer to that question is that in most cases, the marriage would not be enough. You would have to go back. It's only in very limited circumstances do you not have to go back. Generally speaking, just because you're married doesn't mean you're going to get the right to stay here. The test that the Home Office will apply is whether there are any significant obstacles preventing your return, and there wouldn't be. There's nothing that stops you from leaving the country, going back, obtaining a visa and coming back. The advice that I give in this situation generally is this, that if you get married and you have a child here in the United Kingdom, the child would be British, then based on the child, you would be able to stay here in the United Kingdom. So the marriage is not enough on its own. If you have a child, you would be able to stay in the United Kingdom based on your child. If there's no child and you do make the application, to be quite honest, it would be an uphill struggle to get a visa here. It's only in my experience, in fairly exceptional circumstances that you would get a visa to stay here. Now, there is actually a very simple solution to this, which is to go back and apply for a spouse visa from your home country. There's nothing that prevents you from doing that. If you go back, there is no ban which is applied to you. There is no 1 year ban, 5 year ban, 10-year ban. As long as you've not done anything in the United Kingdom, which can be considered as an aggravating factor. So as long as you've not lied in any applications that you've made in the UK, as long as you've not been caught working, as long as you've not made fake applications, etc. If your immigration record is simply that you've overstayed, but it's still fairly clean, then you would be able to go back and reapply and then come back to the United Kingdom. It's not a problem. There is the financial requirement which would need to be met. So your partner in the UK would need to be earning sufficient money to be able to sponsor you. I accept that. And you need to pass the English test, which I suspect won't be a problem because you've been living here. There is this financial requirement that needs to be fulfilled. But in most cases where the immigration history is fairly clean, in my experience, the application is successful. Now, if generally the advice I give is this, that okay, fair enough, you found somebody to get married to, fair enough, get married, start living together. And you can apply if you want, although it'll be unsuccessful. If in the meantime, wife does become pregnant, has a baby, that does obviously then make your application much stronger. You could see how things go. If it's the case that wife isn't pregnant, there's no baby due, anything of that nature, you could then after a while take the view that, you know what, I'd rather go back and get my visa from abroad. So that's perfectly possible to do it that way as well. There's no problem with that. So that, Brother Shabazz, in a nutshell, is the position. Now, another question that's come in is from Muhammad. And Muhammad's question is regarding a spouse application. And he says, I am in receipt of carer's allowance and universal credit. Okay. Don't have any children. Want to sponsor my wife to come to the United Kingdom. Do I need to show any type of employment if I'm getting carer's allowance? I understand I don't have to meet the £29,000 a year requirement. Now, Mohammed, you're quite right. Firstly, you're right. The £29,000 requirement doesn't apply to you. That's the advantage, if I can put it that way, of being somebody who's in receipt of carer's allowance. You're exempt from the £29,000 a year financial requirement. But there is still another financial requirement which needs to be met, which is essentially that the amount that a couple would be receiving, you've got no children, so the amount that a couple would be receiving on income support is the amount that you should be receiving at this stage. So a couple on income support would be receiving, I can't remember the exact figure, but it's in the region of around £144 a week. So you would need to be receiving that amount. Now, in most cases, not all cases, in most cases, somebody who's in receipt of carer's allowance and universal credit, they wouldn't be receiving even combined £144 a week. It would normally be around 110. So you'd be a bit short of the financial requirement, which is the income support rate for a couple, which is, we think, about £144 a week. So what you have to do is rely on your carer's allowance, rely on your universal credit, and then show part-time employment, which could even just be, for £100 a week. Or rely on carer's allowance, universal credit, and savings of, let's say, around £5,000. There's a formula that's applied to the savings, which is converts the savings into a weekly figure, which is then added to your carer's allowance and universal credit. But generally, that's what works. So generally, your carer's allowance and your universal credit won't be enough. It comes up to about £110. You're short by about £35. You can make up that difference with employment, and I would normally advise that have employment for about £80 to £100 a week, or you can make up that difference by showing savings of about £5,000. So in answer to your question, Mohammed, you can rely on your carer's allowance, you can rely on your universal credit. Big plus point, the £29,000 requirement doesn't apply to you, but you're going to have to do a bit more to be able to sponsor your wife to come to the United Kingdom. It's simply a case of a part-time job. You only need a month's wage slip before you can apply. You continue the employment, but you just need to show a month's wage slip before you can apply, or you show savings, but the savings would have to be for 6 months. That's basically where we are. So try, in my view, the quickest approach is to try and show employment along with carer's allowance and universal credit. That brings us to the end of the show. Inshallah, we'll be back next week at the same time. Inshallah, see you then. Assalamu alaikum. Thank you.